And we're live. It is Thursday, August 6th, 5:06 p.m. Let us start with an explanation for why we are late. We are late because of technical difficulties. It's not Kate's internet setup. It's not my internet setup. It is our guests. Difficulty connecting in a fashion that does not produce feedback painful to the ear. So we are going to keep working on bringing Deepak Gupta in to talk about his amazing win on behalf of all of us who use court records today in the Federal Circuit Court of Appeals. We're going to keep working on bringing him in. But in the meantime, I guess I should monologue to stall for time. Unless, Kate, you have a monologue to do to stall for time.
I mean, not really. I don't really I feel like we have plenty to talk about. Anyways, Deepak is back, and try him now.
I don't see him. You mean in the guest?
He might be in the 3 appeared on screen. Go to the thing next to it.
I am not seeing him. So I'm going to keep work on bringing on Deepak, and I'm going to try to...
Are you going to monologue at the same
I'm going to try to do them both, because I've got some
He's
things to say.
He's on the second page. Go to the second page of the guests.
Yes, no, I just saw him on the guests, and I clicked him in, but then he didn't appear.
He'll appear now. It'll happen.
All right, I'm waiting. I'm excited about it. And in the meantime, I want to talk about DHS, because last night 3 documents showed up.
That's exciting.
That actually took me a while to figure out how to read, because they were in DHSEs, and that's a language that I don't speak. I speak FBIEs pretty well. I speak Justice Departmentese very well. I can get by, if need be, in CIA, NSAs, but DHSEs is just kind of like a little bit of a foreign language to me. It's not an agency I've spent a lot of time with. And so when DHS gives me 3 documents describing the changes in the policy document IA-90, I don't really know how to read that. Oh, and we've got Deepak, and let's see what happens if he speaks. How many times do we hear him?
How about now?
Beautiful!
All I did was log out and log back in. I don't know.
Sometimes
that's the equivalent of smashing it with like a hammer.
It's like a reboot, and it's amazing. So I can just wrap this monologue up.
So this is like my nightmare, by the way, is like that this happens to me in like a court. Like,
you know what? Here's the great thing about the nightmare that this happens to you in a high-stakes situation. This is the 133rd day in a row that we have done in lieu of fun. And
in a row, like every day at 5 o'clock, every day.
Rain or shine. I'm sitting out here in the rain, outdoors in the rain. The career-ending tech mistake turns out not to end your career. It's just like, okay, so we're 11 minutes late now, and there are some people bitching about it on YouTube, I'm sure. But
you'll see. How much do they pay us for this show, Ben?
Yeah, exactly. But you'll see if you scroll through the crowdcast. There's not a discouraging word in there, and basically people are pretty chill.
Everyone is grateful for you for showing up, Deepak. It's really nice of you to come join us.
And if one of them were a federal judge, who had jurisdiction over the case, he'd probably or she'd probably be later than you, because they're technically terrible.
Or they would be in the toilet and you.
Yes, exactly, flushing it, and then pretending that it was poor Roman Martinez who did it.
I had one oral argument recently in the state Supreme Court where the IT guy set everything up and then left. And then a few minutes into the argument, you start hearing one end of a telephone conversation. and it was him like in his office, and he didn't realize. And everyone in the courtroom could hear this, and they're like, the justices are joking about it, but there's no way to like get in touch with him.
File him. Oh,
real
geez.
nightmare. But
oh God.
But it wasn't
That's
my
so
fault.
awkward.
You know, my nightmare is that it's going to be my fault. That exactly what just happened is going to happen in like the U.S. Supreme Court.
No, but the thing is, if it did, like, what would happen? Like, Chief Justice Roberts would be like unnervingly gracious about it, and right, like, you know,
I don't even want to. Now I should not even think about this.
He would just express concern that everything was okay, and no, I mean, I think everybody has like gotten pretty chill about tech glitches at this point. We are not allowed to have fun anymore, but in lieu of fun, we do have Deepak Gupta, who did just an incredible service for the community of those of us who use PACER for a living. And if you think about the volume of court documents that gets posted to Lawfare on a regular basis, many of which are not the opinions, but the underlying briefs and motions, and we spend a lot of money on PACER getting those documents, which are public documents and shouldn't cost anything because, you know, PACER we're not using the court's printing equipment anymore. I mean, these are electrons and they shouldn't cost anything, and they're actually pretty expensive. And so on behalf of everybody who publishes documents that belong to the public, on behalf of the public, for the public, you've done a great thing. So tell us about your case.
Oh, thanks. That's really nice of you to hear. Yeah, I was DMing with Kate earlier, and she's like, "We want you to come on to talk about PACER." I'm like, "Are people really gonna be interested in hearing about PACER?" But I understand that you have a very wonky script here, and people will actually be interested.
So first of all, for we have even, you know, Pauline's joining us from Montreal, so she probably doesn't know about PACER. So let's start off with what the heck is PACER, and why should we care?
Yeah, so this is the electronic system that the U.S. federal courts use to disseminate their records, their court records, things that people file, opinions that where judges decide, anything that gets filed in the federal court system. And it started, you know, back in the age of dial-up internet. And so they were actually charging people for like the amount of time that they were on a connection. And at the time, it was a really innovative thing, allowing people to access electronically the courts. And it made sense to charge, I think, at the time to get the thing set up. And so that's how it started. But, you know, over time, the cost of storing PDFs has gone down exponentially. It doesn't really cost virtually anything to store these records and to disseminate them. And what's happened over time is, I think, what happens with a lot of bureaucracies. If you allow a bureaucracy to charge money for something, it's going to see that as a revenue center, as a profit center, and it's not going to let go of that. And so even as the cost of storage has gone down exponentially and the usage of the system has gone up dramatically, so that it's actually the main way, you know, for me as a litigator, I don't ever go down to the courthouse and get paper files, right? It's always an electronic interaction. They've collected hundreds of millions of dollars from people and used it to do things like buy flat screens and, you know, things that are fine. We want the judiciary to be well funded. We want them to be able to do stuff. But this is like the exact wrong way to be funding judiciary operations. It's like a regressive tax on information.
Am I remembering correctly? I'm going back into my, you know, age-old career as a reporter for Legal Times from the dawn of time. But I seem to remember sometime back in the Pleistocene, Congress mandated that the judiciary create a online record system, and also mandated that it get no appropriated funds for it. So it basically had to charge? Is this a judiciary problem or a congressional problem?
It's a little bit of both. I mean, I think it is not an unfunded mandate exactly. So the judiciary was encouraged to have this system. It was authorized to collect fees. And then Congress realized in 2002 that the judiciary was using this as a profit center. And Senator Lieberman was the one who took leadership on this and said, like, basically cut it out. They passed a law that said, you can charge, but you can only charge to recover the reasonable cost of disseminating these records. The statute wasn't as clear as what I just said, but that's the way I interpret it. And so that statute for law geeks, it was like an uncodified note. So it wasn't even in the United States Code. It was just something sitting there, and it had never really been enforced. And so, I knew about this problem, had known about it for a long time. I used to work at an organization called Public Citizen that does a lot of transparency and openness work. And so I had been interested in this, but I thought, and folks may know about Aaron Schwartz, who was an activist on these issues. And
I'm dying. I have like 8 million different, I'm really glad that Ben started this off because his questions are perfect. And now I'm like dying to get into the answers. But let's hold back for a few seconds, because I do think that like Ben's question is great. Like, judiciary problem or congressional problem. The thing is that it ends up being, it switches from a dial-up modem system,
right,
and a time-based system to a per-page system.
Right.
And you have all of these public documents, and as you say, it is no longer like this, like, okay, I go to the clerk of the court, I walk in, I want these documents, they hand them to me, I photocopy them, I walk away, or whatever, or they print them out for me, 3 cents a page, I don't know, whatever. Some of the courts would do that. I remember, like, right. Kind of, ink's not free, paper's not free, but there is this idea that, like, well, it could be free on the internet because it's actually not. It's not ink, right, and it's not paper. And right. Yet, funnily enough, what I think is like the real kind of rub of kind of all of PACER is that they charge you per page, like as if pages exist anymore as a concept, like, right? And so it's just kind of like this interesting kind of like moment, like some asshole just sticks like 10 blank pages into like his brief. It costs you like, another $5 like to print out your PACER document. So I think that this is, anyways, we can get into like kind of all of the nitty gritty, but like, I'm kind of curious, like PACER becomes a cause celeb under Aaron Schwartz, I feel like. And so I'm kind of, I told you, I wanted Corey, I like alerted Corey to this Corey and Larry Lessig, who was on the show a couple of months ago. I lost all time, has no meaning.
There's no time.
Yep. And Oren Kerr, who has been on a number of times, this is all their wheelhouse. CFAA, PACER, this whole thing. Steven Schwartz, who I've never, or not Schwartz, Schultz. Right? Yeah, Steven Schultz, from formerly of Berkman Klein Center, has been a like the guy who was like obsessed with how like draconian this system was. So like when you kind of picked up this case, where did you come into it from? And like how did you kind of, that was like this history of like a lot of people feeling like there should be open access to information. This was this outdated system of accessing public files. I hope.
Where did the case come from, and how did you get involved?
Yeah, so I mean, I had been well aware of this whole history of the, Aaron Schwartz's activism about this problem, how indefensible from a policy perspective this whole system was. Honestly, I kind of thought that the case had been tried, like somebody had actually taken a serious stab at trying this, and that it had failed or something. I don't know. I had in the back of my mind from when I was at Public Citizen that, and I did some other litigation involving sort of very wonky corners of federal jurisdiction. We represented federal judges in a class action about their pay. and some other cases where I realized like there might be a way to get jurisdiction in this case, because how do you sue the federal court system? That was sort of the problem, right? It's a kind of a crazy, audacious thing to sue the federal court system in the federal court system and to say this thing that's earning hundreds of millions of dollars for you is breaking the law. If you're in my line of work, you want to be damn sure that you're right before you do something like that. And so there's no Administrative Procedure Act jurisdiction over the federal courts. That's the normal way that people sue federal agencies, right? So the way we came into court was using a Civil War era statute called the Tucker Act that allows people to bring claims against the federal government for money. And so we realized like each time there's a download, that's a claim under this old law called the Tucker Act. And that's how we were able to sue the judiciary. So it was like,
are you familiar with that? Is that like your bread and butter, the Tucker Act, like, or is that like something that you like found for this specific thing? Because like you've been in the Supreme Court and like appellate court so many times that, like, I kind of wonder how you like manage to get standing every time. I'm kind of like looking around. I'm like, it's kind of amazing. So yeah, that's
always great. The hard stuff in law is like it's not really the merits of the legal theory. It's like, how do you actually get there? Like, how do you get into court? How do you set it up so that you can actually be heard on the merits? I think a lot of what I do is like that. And so in this case, just from some other work that I did, I realized from representing these judges that that's a way you could get into court, is using this obscure law called the Tucker Act to get jurisdiction. And so our case is actually a damages case. So for any of you who use PACER, you have been systematically overcharged over all these years, this case is seeking to get money back to you. At the end of this, you will receive a check. And that was the only way we could get the case into court. So it's one of those things where we're working late at night in the office when we used to work in the office, and I actually wonder whether this kind of brainstorming would happen now, because we're not like physically in a space. And we just kind of stumbled on realizing that nobody had done this and there was a jurisdictional pathway to do it. And we're like, wait, no, nobody has actually done this. We have to do it. And so it's really like kind of fashioned that way as a test case. And then we got 3 nonprofit organizations to be the plaintiffs, the National Veterans Legal Services Program, National Consumer Law Center, and the Alliance for Justice. But really anyone—
it's a nice mix. It's a solid mix. Very like across the board. Like,
yeah, it kind of illustrates the like access to justice problems of this paywall. But there's so many people that are affected by this paywall, like pro se litigants, but also journalists, researchers. I mean, there's a lot of like academic research about the courts that's just impossible to do because of this paywall. It's just, impossible to aggregate data. Elizabeth Warren, this research about, they had to go like court by court around the country to get waivers from PACER, like from, 94 courts just to be able to do that research. It's just crazy.
No, it's totally crazy. And like, I think that there's, I want to get into like, I was reading the New York Times article that you linked to, and I was like, oh, it says it's like the claims that you make, like Adam Liptak is like the claims of the lawsuit are modest, and I think that that's true. And as you said, it's a damages claim, so it's not like you're revolutionizing PACER or PACER in the sense of like you're not mandating that a new payment structure happen or whatever. But I'm actually curious, is that something that could flow from this as part of like the settlement?
I think it has to flow from this, even from a court, even if it's a judgment, because if you're charging something that's illegal, you can't keep on charging that after there's a judgment against you, right? So they're going to have to reform the payment structure. I think Adam is right that it's modest, and I mean this often happens when you take a problem in the world and you have to frame it in the law, you necessarily narrow it, right?
Yeah, Totally.
You almost always do. So I would have loved to been able to just say, look, this should be free. Charging anything is illegal. But obviously we couldn't say that because Congress had at least authorized some charges. And at least, whatever the marginal cost of disseminating that unit of information, like the analogy to like a FOIA fee, right? Where you an agency can charge something for disseminating stuff. That's okay. But what I hope happens is this just demolishes the paywall to the extent that it's no longer defensible. They look really bad. The arguments that they've made are not, from a policy perspective, not really very defensible. And there's bipartisan interest on the Hill in doing away with this paywall altogether. So I hope that, I think a lot of times litigation kind of narrows the problem, but also focuses people on why a policy can't really, survive scrutiny. And so I hope
let me give bring that down to brass tacks. I mean, a few years ago, a couple colleagues and I did a study of sextortion, and the subject had never really been studied before. And it turned out that the vast majority of prosecutions for it were in federal court. Mm-hmm. Nobody had ever collated them all and sort of identified them all. And so basically the project was going through hundreds and hundreds of news clippings and lining them up with cases in state and federal court. And in the cases that were in federal court, of which we ultimately identified probably 100, which we excluded, 100 that we looked at, 80 that we used in the study. You had to go in and grab all the documents from the docket, all the documents that describe the substantive conduct of the case. So this is tens of thousands of pages when everything is said and done. It was the major cost of doing the study was, the $2.30 docket reports with the, then right. As you identify documents, you have these very small amounts of money that add up into a very large amount of money by the time you're done. And you end up paying 10 cents a page. And it's completely indefensible. It's very much research in the public interest. And the marginal cost to the federal judiciary of your using the system that way is zero. Yep. And so obviously, the right answer is for Congress to appropriate the amount of money that it costs to run the system, or to have some user fee associated with using the system at all, but the marginal cost per page downloaded should be zero because the marginal cost per page to the government is zero. Right. Anything else is just profit taking, right?
Right. That's right. And it's basically, people have offered to pay for the cost of running this system, which is, virtually nothing. That's not what they're interested in. What the administrative office of the U.S. courts has become interested in is just kind of protecting this revenue stream. And it's pretty silly because it's not even that large a percentage of the federal court's budget. I realize the federal courts should get more money from Congress than they do, and they're always having to beg. And John Roberts likes to point out that they're a whole branch of government that's doing a lot with a very, very small amount of money. He's right about that. But this is just a dumb way to make up for whatever shortfalls there are, because it's just, it's charging for information, and including from people who can least afford it, or just, creating obscurity or creating practical obscurity for the information where it's just impossible to aggregate and study it. So it's dumb, and there really are no defenders of this policy other than the institutional judiciary itself. One of the things we did in the case is we got a whole bunch of former federal judges to weigh in and say this is bad
that
policy.
Was cool, by the way.
Yeah,
that was because a cool move.
when you're suing the judiciary, you really want to show that you're not I think that we're not crazy people, right? There is this almost like that scene in Austin Powers where he's it's hundreds of millions of dollars or something like that, right? We're suing the federal judiciary and asking for hundreds of millions of dollars. It might sound crazy. And so it was really important to try to show that it was actually a fairly modest claim. In the appeal, the court said we're not finding that every single use is improper. They sort of tried to split the baby a little bit. So I don't think the U.S. Supreme Court is going to have a great deal of appetite for a case like this. So I think at this point, the ball is kind of in the judiciary's court, the institutional judiciary, about what they want to do. But they're going to, I think, two things are going to happen. They're going to have to send a whole lot of money back to people. They're going to have to reduce the fees that they're charging people. And then I guess they're going to have to decide, do we really want to persist with this policy going forward?
And just to follow up on that, do you think there's any chance that the judiciary will ask the Supreme Court for cert?
Well, I can't say that there's no chance. I don't think it's a cert-worthy issue. There's no split. There couldn't possibly be a split. It affects this particular issue, but there aren't really cross-cutting legal issues in the case, as far as I'm concerned. And when we represented, I mentioned we represented these federal judges in litigation over their pay, which is part of what gave me the idea about the jurisdictional theory here. I think the Supreme Court wanted to stay as far away from that litigation as they could. I think that the Supreme Court is not interested in litigation that involves the institutional prerogatives of the judiciary that directly. So I just think, I don't think there will be a lot of interest in getting involved.
So I realized we were kind of running late with tech issues, and so we dove straight into this cool case that you just that you are talking about, and you talked about for the last 25 minutes or so, but I didn't even get a chance to introduce you. Which is kind of ridiculous. No, I'm sorry. And so everyone, this is Deepak Gupta. I know Deepak because he was ahead of me in law school at Georgetown, and then and we've had a bunch of people on from the Flophouse. Julian.
Oh, you have? Oh, cool.
Yes.
Okay. Yeah.
Julian and Adam, Surer, and then awesome. Who else? Matt Iglesias. Yeah. A bunch of people have been on. It's been really lovely. And so people know about the Flophouse now. There have been many stories told, but you used to hang out in the Flophouse, and that's also kind of, I met you at kind of some of the parties, and then we kind of were oh, I was a law student at Georgetown. You had just graduated. You were doing this kind of amazing work, and you started your own. You had a very, I will say that boutique Supreme Court litigation is one of the most kind of it is, I would say the creme de la creme, or the apple in the eye of many a young lawyer who wants to really be a litigator, and it's often a very elite and kind of I don't know, and not just elite, it's just kind of cordoned off from a lot of people. You have to have gone to Yale and gone to Harvard and actually had it, had all of your your district court, your circuit court, you're in the right circuit court, and then your Supreme Court clerkship.
Yeah.
And then you go off and you go and you are a partner or whatever at some other boutique law firm for 10 years, and then finally you strike out on your own, and you bravely started your own firm. You just did it. And it's kind of, I've always thought it was incredibly amazing. You were really successful. You continue to be successful, obviously. You do great work. Tell us about how you started it and kind of your path to kind of getting here.
Well, thanks. Yeah, that's a very generous introduction. I mean, I never, I didn't go into law thinking this was the kind of thing I wanted to do. I went in to do public interest work, however I broadly construed that. I don't really know. I think like maybe when I was, like I had in mind civil rights and civil liberties just because like that's what I knew. So like I probably, if you had asked me when I was in law school, what do you want to do when you grow up? I would have said like, I want to be an ACLU lawyer, which I still think is a really fantastic job. But you know, I went to work for this place called Public Citizen, which has a fellowship working on Supreme Court cases. And what the lawyers there realized is that
wait, can I just cut you off for people who don't know?
Yeah.
The Public Citizen Litigation Group is a kind of legendary public interest litigation shop dating from the 70s. I think it was originally founded by Nader, but it has been for many years the project of two very great Supreme Court advocates, Alan Morrison and David Vladeck, who is the uncle of Stephen Vladeck.
Oh, really?
A regular on this show.
I never knew that.
Cool. And they have.
Do you think those Posners are related?
They cultivated just an incredible group of sort of multi-generational group of public interest appellate law folks. And actually, in the conservative judicial revolution, the Public Citizen Litigation Group was always the group that people pointed to and said, why don't we have stuff like that? And that gave rise to things like the Pacific Legal Foundation and the Washington Legal Foundation. Right. And so all of that is merely by way of background that what Deepak is talking about here is not just any place to camp out and spend some time doing public interest work.
Yeah, no, I was in total awe of the lawyers there that I worked for, and I like just couldn't believe my good fortune to end up there. And actually, David Vladeck was my civil procedure professor. Like there were a bunch of people that I had in law school who were affiliated with Public Citizen, and so I learned about it. Actually, I was at the ACLU and I was working on a prisoner's rights case in the Supreme Court, and that's how I learned about this fellowship that Public Citizen had, where a new lawyer who's fresh out of clerking could work on Supreme Court cases and help the little guy out in Supreme Court cases. And that was the innovation that they had at Public Citizen. They realized that the Supreme Court bar is very overwhelmingly on the corporate side, representing the federal government or corporations, and there is not a Supreme Court bar for, say, a tort plaintiff or a legal aid lawyer or a public defender to turn to. And so what they realized is that they had accumulated enough expertise in Supreme Court litigation that they could set up a project to help out other people. And my job at the time was like I would go down to the Supreme Court and like go to the mailroom and go through the cert petitions. That was, and then we would write memos on them and we would get in touch with people. Now,
do you have any insight into how they actually pick those? I've always wanted kind of besides the obvious.
How they pick the cases, you mean?
I mean, I know the obvious things like circuit splits and whatever, but just kind of how they get debated. I've always kind of I've never actually heard what the process is for voting on cert and discussing cert with all of the justices. Do they batch it? Do they do it by area? How do they end up? I just wonder how they split it up.
There's not a great mystery about this. I mean, some of this is pretty systematized, and what they do is they create a list. They created a list called the discuss list, which is the list of cases that they will actually discuss and vote on at conference, which is a relatively small subset of the cases. And what I realized, just as someone who, what did I know? I was just starting off doing this, but once you start going through them and you do this routinely enough, it's not rocket science. You can predict which cases are actually serious cases that are going to end up on the discuss list, and then which cases will likely be granted. And, you know, there's this lawyer, Tom Goldstein in Washington, who he was doing that. He was the only person I would ever see there in the mailroom, you know, who was also doing this. Because back then you couldn't look this stuff up online, right? You had to go down there. And so it's not that mysterious a process. It just, there's a real inside baseball to the way the Supreme Court works, which renders it pretty inaccessible and creates it gives a really big advantage to repeat players and to people that are following the work of the court closely. And the problem is that repeat player advantage almost always goes to well-resourced litigants, right? So if you're a large corporation or if you're the federal government, you have access to that information. If you are, you know, some solo practitioner somewhere whose client has been injured, you have no access to that information. You have no idea what you're doing, what that document should look like, how it's going to be treated when it gets there. And so a big part of what we were doing was trying to figure out how do we leverage, you know, what we've learned and try to help people. And so that was just like my dream job, and I thought I would just stay there forever. And in a way, what I'm doing now is just like private citizen litigation group. It's like the law firm version of what they were doing. And the only reason I left was when Elizabeth Warren was starting the Consumer Financial Protection Bureau. I just felt like I had to go there and work for her and help set this thing up.
Were you there while Erie was there?
I was.
Oh,
yeah,
okay.
yeah. Another friend from DC who
from that group. Yeah, she was working for Elizabeth Warren. Now is she still at the FCC? I think she's still at the FCC.
Yeah, she's there. She's working for Rohit Chopra as a commissioner.
Yeah. Cool. Yeah, no, that's a really great explanation, but I still think that it's pretty awesome. I mean, like, public citizen is like a huge deal, but it's also like, it's like a brave thing, like, to set up your own shop. I mean, it's one thing to like put out your own shingle, like my dad did that. I still think that was brave of my dad to like just start representing people on like traffic tickets and like doing their wills and like everything else, right? That's like hard. That's like, you know, you have to trust yourself that you're getting it right and you're not screwing your clients. But, you know, this is the same thing with appellate litigation. You're promising people big return, you know, they're at the upper levels of like being serious about what they're working on. And like, you know, you're like, hey, trust me with this. I can do it. And my Second Circuit judge loved you when you were in the Second Circuit.
Who was your judge?
Judge Wesley.
Great.
He was like, I think I mentioned to him, I just sent him a text because I saw you were appearing in oral argument. And I was like, oh, by the way, like, what did you think? And he was like, he was incredibly calm and very easy to listen to and very well spoken. And I was like, solid.
That's nice. He gives me a really hard time in a few cases that I can think of.
He does that, but that means he
very intense at argument. But, you know, like, I would never advocate somebody like starting something like this, like right at the beginning. Like, there's so much you can learn from people, you know, and I think I was only comfortable doing it because I gotten to the point where I have some relationships with people that I think I'll be able to work with on cases. And like, I think I can put together a group of people and maybe this will work. Hey.
Sorry, I was waving to Zach. Zach is a repeat questioner. He has good questions. Zach, go ahead.
Oh, my dog might be joining us. This is Wigan.
See, I told you your cat would be welcome here, except with the dogs.
He's sleeping. I'll try to see if I can interest him in this.
Oh, all right. He wants to be between me and things, but so maybe not. You're wonderful. But so I would see PACER as kind of like a raw data resource, and I'm going to make an analogy here to, and this is kind of why I'm excited for tomorrow, to clinicaltrials.gov. So one of the things my company does is we kind of like ingest clinicaltrials.gov and turn it into a format that is more useful for the things people want to do. And we call that the knowledge base. So I was just wondering, do you have a favorite knowledge base for judicial documents? One, because I don't know things, and that's an interesting thing. And two, does the getting rid of like the per page issue like help with this kind of thing?
Yes.
And like secondary to that, natural language processing is becoming like a lot easier these days, but you need a lot of data, and it becomes super prohibitive cost-wise if it's per page. Like 1 million documents is not that many documents, but if it's 10 cents per page, it's a lot of money. So I don't know, I'm just kind of excited for the kind of research that could be done using all this stuff.
Those are excellent questions, and we had a whole amicus brief from the legal technology, legal informatics industry, making this point to the Federal Circuit. And remember, the Federal Circuit is like the court of innovation, right? They do patents. So we wanted to explain to them how this paywall inhibits a lot of technology that would make the law better available to people and process the law in ways that people can understand better. So there are companies that are doing this. A friend of mine, a former intern of mine, started a company called CaseText. That's one. There are a whole bunch of these companies. Mark Lemley.
Lawfare has a relationship with CaseText.
Oh, yeah. And Mark Lemley, I don't know if you've
I love Mark Lemley.
Yeah, he's great.
He's a good friend. Yeah.
He has a startup like this, and he helped us put together this brief of all of these companies. They're doing amazing stuff with legal information. We're still kind of, I think, sort of in the dark ages on that. But having a paywall greatly inhibits the ability to get all of that information and process it and analyze it. And it's another way, that the law is not as accessible to people, right? And something like Westlaw, nobody can afford that.
No one can afford Westlaw. It is so expensive. People write off my professor Westlaw account so often. I give it out to everyone.
Don't say that in public, Kate.
I know.
Can I just add that
so you should be.
You're right. No.
Can I just
represent me?
Can I just say that the information monopoly that Zach is referring to here is not simply a function of the federal government and the federal judiciary. It's Westlaw plays a very big role in this,
right.
And as late as I don't know when they finally relinquished this claim, but as late as the late 1990s, Westlaw asserted a intellectual property claim over the citation system that the federal courts use to cite documents.
Right.
Or shepherding, isn't shepherding?
Right.
Shepherd is a company,
right? Right, but they still assert an intellectual property claim over their head notes, and they do have an exclusive contractual arrangement with the federal courts. So by doing that, what they say is these reporters that are the official reporters, that some company can't just harvest those. And so I remember when Jay Keller, who's the founder of CaseText, when he was trying to figure out how to do this, they had to go to incredible lengths
to strip stuff out.
To strip stuff out and process it so that they weren't violating Westlaw's copyright.
Right, but Westlaw used to contend, and I don't think they still do, that if you used a West pin site without their authorization, you were violating their...
I don't think they say that anymore. That's absurd.
I think they dropped that in the 90s, but they had it was sufficiently long-standing that when Cornell started posting Supreme Court opinions, and of course at first they only did stuff forward-looking, they would make a point of not including the West citation, which of course made it much less useful.
That's just ridiculous.
And there was who was it? It was a guy named Jamie Love, who was obsessed with creating a public domain citation system. And Westlaw fought that with a tenacity that it was actually hard to imagine. And I think it was really only after their acquisition, when it stopped being a family company. It was owned by a single family in Minnesota for a long time. it was only after its acquisition by Thomson, which was a Canadian conglomerate, that it kind of chilled out over some of those
they've
issues.
chilled out over that, but they haven't relinquished their claims over these head notes. They haven't relinquished their monopoly over the official federal reports of what the courts do. And so it's a big problem. And I really do think for the average person who's trying to, let's say you have some case about, I don't know, a foreclosure, or you're litigating with your landlord. There's a tremendous disadvantage that you have. You think the law is available to everyone, but it's not. Right?
No, that's the critical point. The extant cases you're paying 10 cents a page to the judiciary for, and historical materials, except the stuff that happens to be Googleable because it exists from about between 1996 and now. So that stuff you're going to be able to Google unless it's relatively obscure. Everything else is owned by Westlaw. And so, the percentage of legal materials that are in the public domain that the public owns and yet the public doesn't really own in practice is huge. And it's poisonous stuff.
Yeah, no, and there are companies that are working to try to democratize, the law, the access to this information. And I think that they were very supportive of this litigation that we've engaged in for this reason, because they now can get this stuff for free, or not for free. I mean, we'll see. I don't want to count our chickens before they've hatched, but it will certainly make it cheaper and easier for them. And I think eventually free.
So has there been any statement from the judiciary about what they're going to do yet, or is it still too soon?
I'd be, I'm sure they're going to have to think about it. It just happened today.
Yeah. So I want to tell a funny story before we're getting close to having to wrap, but I want to tell a funny story. And this is actually about the intersection of this issue, if they do become public documents or whatever else, and the CFAA. So I was clerking for the Second Circuit. And for people that don't know, when the Second Circuit hears a number of cases, and it's direct appeal. So everything, if you decide to appeal it from your trial court, which was the fact finding court, and you don't like the decision, it goes up to and you're in the right geographical region, it goes up to my court, and the court that I was clerking on, and then we would hear the appeal. And we would rank as clerks, we would rank all of the various appeals that came in every kind of sitting as in difficulty and difficulty and length of briefs and all of these other issues, to try to figure out what was going to be the things that were going to be easily decided, and the things that were going to turn into what would ultimately be precedent setting opinions that would be kind of interesting legal problems, right? But if it wasn't a precedent-setting opinion, what happens is that those cases get what's called a summary order, which is a very short or supposedly short summary of basically just we affirm the district court decision. What is interesting is that under various chiefs of various circuits, these summary orders have gotten lengthier and lengthier and lengthier. They have moved, they have facts in them, they have opinions, they have analysis, they have all of these citations. It has gone from being a perfunctory kind of absolutely zero sum, here, you lose, goodbye, kind of thing, to being these mini opinions.
Mm-hmm.
Here's how this matters. Summary orders are not are not precedential opinions. But when you start pushing a bunch of fucking facts into something, and you publish it with a court, everyone is going to look at it, and whether it's precedential or not, whether it means something or not, they're going to think that it does, and they're going to use it as that, and that's going to slowly become mini types of opinions, even though that's not what the judges voted on, that's not what it stood for, that's not whatever. So all of this is to say, that at the end, like this was happening while I was in the Second Circuit. There were all of these long summary orders, and my judge was pushing back and pushing back and pushing back. And I had this idea at the end of my clerkship that I would scrape all of the summary orders, which were free, or freely available, because they, like, the Second Circuit publishes all the summary orders on its website. I would scrape them from the internet. And so I had my partner, who is a programmer, build a scraping tool to scrape them all, and which was promptly shut down because it set off a bunch of alarms. And then we did it again, and I got the rest of them. And when I ran all of the analysis, the word count was that the greater the word count of the summary order, the more often it was cited in Westlaw, even erroneously, in subsequent decisions. And I was like, fuck you. I would never have been able to do this analysis if I hadn't had free access to the summary orders, ever, in a million years. And I just kind of think this is exactly what Zach is talking about, and all of these other types of things. The longer the summary order, the more likely it is to become actual precedent, even if it's not. And it's kind of a crazy normative piece of judicial procedure that people don't understand fully, but you kind of get, and Ben gets, so I'll tell the story. But it was a fun experiment.
Yeah, no, that's really interesting. I mean, I think, look, I mean, at a certain level, is it really law if it's not accessible to people? I mean, there was a Roman emperor who used to put the law really, really high up on columns, so people couldn't see them. That's not law. Law, I think, part of the concept of law is that it be accessible to people, that everyone sort of knows what it is, right? And the problem now is we have a system where if I can hire a big fancy law firm, I know what the law is, and if you can't, you don't.
Yeah, I think that's right. That's a little, yeah.
We're going to leave it there. Deepak, congratulations.
Okay, sorry that the technical difficulties are.
No, you've done an amazing public service, and you've undoubtedly saved Lawfare a lot of money, and by Lawfare here, I mean, and all organizations that do research in order to make information public. And we all owe you a big thank you. And also information that is the public's law ought to be available to the public, quite apart from the pecuniary impact on Lawfare. So thank you very much for this, and thanks for coming on the show.
Thanks for having me. This is great.
I'm a little sad I didn't get to see more kittens, but I will let it go. Let it go.
We'll do it again sometime.
This was really fun. Please come on again. This was really great.
Take care.
So tomorrow on the show, we have my mother, who is speaking of clinicaltrials.gov, is going to talk about clinical trials and what the impact of COVID has been on ongoing clinical trials, how you run a good clinical trial. So my mom did a lot of pioneering work on just making clinical trials more evocative of better information, how to design them so that they don't produce garbage at the end of 10 years of data gathering, and also how you do them really, really fast, which is something you are not supposed to do as a general matter. But in the COVID environment, there's a pretty good argument for doing clinical trials really fast. So how do you do that? Also, my mom is good fun and good person to hang out with. So we will be back in 22 hours and 58 minutes with Mom. And until then, Kate, what do we say?
We don't have fun anymore. But in lieu of fun, we have much better access to legal documents for which to base our suits against people. I don't know.
Yeah, that one kind of petered out, Kate. All right.
Sorry.
We will see you tomorrow.
I hate this. Sign off. Bye, guys.
Bye.